February 12th, 2026. At exactly 9:14 a.m. Greenwich Mean Time, a legal filing was submitted that sent shockwaves through royal institutions on two continents. Just 72 hours earlier, the palace had stripped the Sussex family of their remaining royal privileges. And then, without warning, Meghan Markle made a move almost no one expected. She filed a formal claim to take full ownership of Brook Hill, a 72-acre estate in the Cotswolds long connected to royal lineage planning. According to royal legal officials, this was not just a property dispute. It was a direct challenge to the monarchy's control over legacy. Brook Hill is not an ordinary residence. It is a protected heritage estate that was once part of the Highgrove complex. The property includes a Grade II listed Georgian manor house, a royal-funded equestrian center, multiple vineyard parcels, preserved agricultural land, and full Crown trust protection. In 2025, it was valued at £19.6 million, making it one of the most valuable unassigned royal estates outside Balmoral and Sandringham. But its true importance is not financial. It is symbolic. Internal royal planning had identified the estate as a future lineage residence connected to Prince Harry's branch of the family. And now, that future was being claimed in court. Meghan's legal filing was submitted simultaneously to the UK Crown Property Commission and the California Superior Court. Both filings relied on a little-known transnational framework known as the Windsor California Reciprocity Accord, which governs certain cross-jurisdictional royal property matters. Her attorney, Sher Tilden, issued a clear statement. He said his client intended to exercise her lawful and equitable interest in the estate known as Brook Hill. He stated that the property had been promised as a family legacy, not something to be used as punishment during divorce proceedings. According to the filing, the late Queen Elizabeth II had verbally committed the estate as a future marital residence and inheritance for Prince Harry and his direct family. The legal argument was simple but powerful. Even if formal transfer never happened, the promise created a legitimate family interest. In other words, the estate may legally belong to the Crown. But Meghan's legal team claims it belongs to Harry's family in principle. Less than 3 hours after filing became public, Buckingham Palace issued an unusually rapid midday statement. The response was direct and unmistakable. The palace declared that no formal or informal commitment had ever been made to transfer Brook Hill to the Duchess of Sussex. The property remains a Class A Crown Trust asset under sovereign authority. Royal legal advisor Sir Alaric Mansfield clarified further. He stated that any verbal assurances given before 2021 are legally void. Why? Because when the couple stepped down from royal duties in January 2020, property rules were revised. Those revisions were later formalized in the Sovereign Property Charter of 2023, which extinguished all unexecuted lineage allocations connected to non-serving royals. In simple terms, leaving royal duty cancels future claims to royal property. But inside the palace, the move was not seen as a simple property request. Royal aides reportedly viewed it as a calculated pressure strategy, an attempt to reopen negotiations that had just been closed. Custody, financial arrangements, brand control, institutional status. One senior insider described it plainly. This is not about land. This is about leverage. The timing was critical. Just days earlier, the palace had issued a sweeping declaration removing the Sussex family from remaining royal privileges, legal honors, and institutional custodial rights. The power structure surrounding the children had already shifted. Legal analysts quickly noticed something important. By asserting property rights tied to Harry's lineage, Meghan could position herself as a co-beneficiary of ancestral assets. That status could influence how courts view family stability, living conditions, and custodial qualification. In legal strategy, property is not just an asset. It signals legitimacy. Documents later obtained by the London Sentinel revealed another layer inside the filing. Meghan's legal team referenced what they described as property-based fitness for guardianship. The concept is simple but highly controversial. If a parent can provide a residence that meets royal standards, that parent could argue they are better positioned to support children of royal status, even if institutional guardianship already exists. Legal experts warn that this argument could create a new pathway for challenging custodial authority across jurisdictions. One royal advisor reacted with concern. "She is not asking for a home," he said. "She is trying to requalify herself as part of the royal system by proxy." Before speculation could grow further, the California Superior Court issued an early jurisdictional clarification. The court stated that sovereign property entitlement claims cannot influence custody decisions unless they are formally recognized by both the UK Privy Council and the Crown's Diplomatic Property Registry. Legal scholar Dr. Henrietta Akins explained the significance. The court is drawing a boundary. Royal property claims do not automatically prove parental competence. Institutional validation and custody are separate legal matters. In effect, California signaled that property arguments alone would not change guardianship, but the conflict was already expanding. Internal royal records indicate that Renbrook Hill had been placed in reserve in 2020 through a sealed letter of intention from Queen Elizabeth II. The plan identified Prince Harry as preliminary trustee for future lineage planning. However, the trusteeship was never formally enacted. The couple's departure from royal service halted the process. Since then, the estate has remained inactive, held in trust under the Duchy of Cornwall and occasionally used by senior royals during hunting season. In late 2025, Princess and reportedly suggested reassigning the estate to Lady Louise Windsor as part of a youth development initiative, but no official reassignment had been confirmed, which meant the estate remained technically unassigned. And that legal ambiguity is exactly what Meghan's filing targeted. Then something highly unusual happened. Several senior royal figures issued a rare joint public comment from Sandringham. Their message was brief but sharp. What began as a request for autonomy, they said, has become sustained institutional provocation. The Sussex brand is no longer a symbol of personal freedom. It is a weapon, and the victims are the children. That statement marked a turning point. The situation was no longer framed as a legal disagreement. It had become an institutional conflict. Royal legal offices quietly began drafting a supplemental directive that could permanently restrict Meghan Markle from using the Windsor name in legal claims, property assertions, or media representation. If enacted, it would create complete legal separation from royal institutional structures. Inside royal circles, a new phrase began circulating: the post-Sussex purge, a coordinated legal, financial, and reputational containment strategy. If the February 12th filing was meant to open negotiation, it had the opposite effect. Within 24 hours, the royal household did more than reject the estate claim. They initiated a full financial review of all assets connected to the Sussex marriage. The review activated clauses from the Royal Matrimonial Contract of 2020, a document many had believed to be purely ceremonial. It wasn't, and now it was being enforced. The property dispute had triggered something far larger. This was no longer about land. It had become a complete examination of wealth, rights, and status. And this was only the beginning. February 12th had already triggered a constitutional confrontation. But what followed next transformed the situation from a property dispute into a full financial war. Within hours of rejecting Meghan's claim to Renbrook Hill, the royal household initiated what insiders described as a comprehensive asset exposure review, a complete forensic examination of everything acquired, shared, leased, gifted, or financed during the Sussex marriage. This review was not symbolic. It was legal, and it was grounded in a document few people had ever taken seriously: the Royal Matrimonial Contract of 2020. For years, the agreement had been viewed as ceremonial protocol, a formality attached to royal marriage. But now, palace legal teams confirmed it was fully enforceable, and it contained provisions allowing institutional review if marital breakdown intersected with royal financial structures. That threshold, the palace argued, had now been crossed. Princess Anne's Office for Sovereign Integrity authorized royal accountants to release a structured asset breakdown. For the first time, the financial architecture of the Sussex household was laid out in detail. The Montecito mansion, valued at approximately $14.2 million. Tyler Perry's temporary estate, previously used in 2020 under Archwell rental arrangements. 2 Rolls-Royce Cullinans leased under Archwell. A Range Rover autobiography, gifted by King Charles in 2019. Liquid financial holdings estimated at $4.7 million across savings, cash reserves, and low-risk investments. jointly held business equity, including Archwell Media, with 33% registered under Meghan's name, and Archwell Audio, holding 16% post-Spotify restructuring. Then came the liabilities. More than $2.3 million in credit obligations, primarily linked to wardrobe expenditures, public relations campaigns, and international brand travel between 2023 and 2025, including high-value promotional activity in Dubai. This was no longer a private financial landscape. It was institutional evidence. Meghan's legal team responded quickly. They demanded a 50-50 division of all domestically acquired marital assets, citing California community property law. But palace lawyers pushed back immediately. Their argument was blunt. Many acquisitions, they said, were not marital purchases, but sovereign gifts, trust-based allotments, or royal status-dependent provisions tied specifically to Prince Harry's institutional standing. Sir Alaric Mansfield delivered the palace's position in a single line that spread rapidly across media outlets. You cannot both reject the crown and claim its privileges. The financial battle escalated further when Meghan filed a second motion in California family court. She requested monthly alimony of $215,000 for a period of 5 years, citing career disruption, reputational damage, and long-term economic impact resulting from royal institutional pressures. Prince Harry's legal team responded with what insiders later described as a devastating counter-submission. The filing included documentation showing Meghan had signed a waiver in July 2020 relinquishing future claims to royal subsidies in exchange for independent branding rights. It also presented evidence of unreported income, including earnings from a 2023 Dubai speaking tour and private sponsorship agreements estimated at $6.1 million. Harry's lead attorney, Miles Armitage, summarized the argument in language that immediately drew headlines. You cannot claim victimhood while profiting from the platform. Alimony is for caretakers, not entrepreneurs in heels. But the financial dispute was only one front of a much larger conflict. At the same time, Meghan submitted a motion regarding child support, and this filing stunned observers on both sides of the Atlantic. Prince Harry had proposed a monthly support structure of $68,000 to cover the children's full educational, medical, and living expenses. Meghan rejected it. Instead, she demanded $22,000 per month, but with strict conditions. All expenses would require direct invoice verification, no extracurricular activities unless pre-approved, no Windsor-branded affiliations, and most controversially, full access to and control over the children's digital image rights, including social media presence and potential publishing or licensing opportunities. That final condition triggered immediate alarm within the Royal Child Welfare Committee. Within hours, the palace issued a new legal clause. Effective immediately, no commercial use of Archie or Lilibet's names, likenesses, or personal identifiers could proceed without dual consent from both the Crown and Prince Harry. The message was unmistakable. The children were not negotiable assets. As tensions mounted, palace investigators uncovered something that deepened institutional concern even further. A sealed branding document dated May 2025 titled Project Emancipation. The internal deck outlined a long-term strategy to position Meghan as a global post-royal identity figure within the wellness and lifestyle markets. The proposal specifically recommended excluding the children from public brand representation. That revelation directly contradicted her current legal claim that she had sacrificed personal branding opportunities in order to prioritize motherhood. Within royal legal circles, the contradiction was described as strategically damaging. Public reaction was swift and deeply divided. A Daily Mirror flash poll conducted February 14th showed 74% of UK respondents opposed Meghan's estate claim. In the United States, 61% believed she should receive no alimony. 82% supported Harry retaining primary custodial authority under institutional supervision. Corporate partners began responding almost immediately. Vogue Arabia withdrew a planned feature cover. Chanel quietly rescinded a Paris Fashion Week invitation. Netflix executives suspended all in-development Sussex-related productions, citing contractual instability and reputational risk. Then came a moment that carried enormous symbolic weight. Princess Catherine delivered a brief public statement during a scheduled appearance. Her tone was calm, measured, almost gentle, but the message was unmistakable. Children are not branding tools. They are not passports to power. They deserve privacy, protection, and peace. The statement contained no names, no accusations, but the target was clear to everyone listening. By this point, what had begun as a property dispute had evolved into a multi-front confrontation involving finances, reputation, parental authority, and institutional control. And then the conflict crossed an entirely new line. Facing mounting financial scrutiny and property rejection, Meghan launched what royal insiders would later describe as her most aggressive move yet, a direct challenge to Prince Harry's fitness as a custodial parent. A sealed filing submitted to Santa Barbara Family Law Court contained serious allegations: historical emotional volatility, alcohol dependency, coercive behavior during marriage. The 32-page declaration included references to a psychiatric assessment from February 2021 describing unresolved trauma responses. It cited emergency therapy sessions in 2022 allegedly triggered by verbal outbursts. It included testimony from a security consultant claiming that during a 2023 argument about Archie's schooling, Harry threw a mobile phone against a wall. The documents had not yet been independently verified, but the legal request attached to them was immediate and severe: temporary suspension of Harry's custodial authority, pending a new psychological evaluation. The palace responded within hours. Their rebuttal outlined Prince Harry's completion of a 12-week therapy program at the Royal Veterans Mental Wellness Clinic in 2021. It documented successful family counseling reviews under the 2024 Royal Reconciliation Framework. It presented records of consistent supervised parental conduct through late 2025. Harry's attorney called the filing weaponized desperation cloaked in concern. To reinforce their defense, Harry's legal team submitted audio testimony from 3 child welfare mediators who had overseen his supervised video sessions with the children. Each described his behavior as emotionally attentive, stable, and cooperative. The custody battle had now moved beyond property, beyond money, beyond reputation. It had entered psychological territory, and the consequences of that shift were only beginning to unfold. The legal confrontation had now expanded beyond property, finances, and custody claims. It was becoming a battle over jurisdiction itself. Within days of filing allegations against Prince Harry, Meghan's legal team launched another move, this time targeting the structure of royal guardianship at its foundation. They submitted an appeal to the Court of International Family Law Cooperation, arguing that royal custodial authority could not override the biological rights of a mother under United States federal law. Their argument rested on 3 core points. First, that maternal preference principles in early childhood custody should take priority over ceremonial or hereditary guardianship structures. Second, that foreign royal titles and institutional designations should not automatically carry legal weight inside California family courts. And third, that inherited royal systems possess structural power capable of shaping legal outcomes in ways that disadvantage private citizens. In a forceful statement to press, Meghan's attorney framed the dispute in stark terms. "This is not about royalty," Shertilden said. "This is about a mother protecting her children from systemic erasure and psychological manipulation." But the palace moved quickly to counter. Within days, the royal household released a signed copy of the 2020 Sussex Marital Compact, a document drafted under Queen Elizabeth's legal office and co-signed by foreign policy liaison officials. The compact included a clause stating that in the event of international relocation or marital separation, custodial oversight could be assigned to Crown under agreed sovereign family protocols. Legal scholars confirmed that the agreement, while highly unusual, was enforceable under dual sovereignty cooperation frameworks between the United Kingdom and the United States, including provisions reaffirmed in the Royal Heirs Treaty of 2017. That disclosure weakened Meghan's jurisdictional argument significantly. Public perception began shifting as the legal complexity deepened. A global YouGov survey showed declining support for her position across multiple countries. In the United Kingdom, only 21% of respondents believed she should regain partial custody. Among American women aged 25 to 44, a majority agreed with the statement that the children were being used as leverage in a broader conflict. In Canada, many respondents expressed concern about attempts to override cross-border legal agreements through media pressure. Inside royal circles, attention turned increasingly toward the children themselves. Prince William, who had remained largely silent throughout the conflict, made an unannounced visit to the Royal Pediatric Trust in Windsor. He met privately with therapists, educators, and security specialists responsible for the children's daily care. A palace aide later shared a quiet remark attributed to him. "We don't need headlines. We need peace, and we will give them that, even if she won't." While public attention remained fixed on court filings and legal statements, confidential negotiations were unfolding behind closed doors. A leaked internal memo outlined Meghan's final settlement demands: 50% of Archewell's remaining value, including projected production revenue from previous years, full ownership of all joint image rights involving the children, a one-time estate transfer equal to the assessed value of Rimbrook Hill, and a formal apology from the palace acknowledging emotional mistreatment during her time as a working royal. Every demand was rejected. What followed was one of the most coordinated institutional responses the modern monarchy had ever executed. Royal insiders began calling it the Windsor Firewall. It was not a single action, but a system-wide containment operation designed to secure digital, financial, and symbolic control across all royal-adjacent structures. At precisely 6:30 a.m., the Royal Office of Digital Ethics, working alongside the Privy Council's Communications Division, issued classified directives to more than 20 major platform partners, including YouTube, Instagram, Meta, Spotify, and Netflix. The instructions were sweeping. All Sussex-branded content stored in Crown-affiliated archives was to be removed or reclassified. All digital uses of the children's names and images outside authorized institutional channels were to be immediately disassociated. Algorithmic amplification of legacy Archewell content indexed under royal identifiers was to be frozen. Legal authority for the action came from Article 9 of the Sovereign Identity Preservation Act, enacted in 2023 following Queen Elizabeth's passing. The law granted emergency powers to protect minor heirs from unauthorized commercial exposure. By midday, more than 380 digital assets have been flagged, restricted, or demonetized across platforms. Content that had once dominated royal search results began quietly disappearing. At the same time, the UK Charities Commission announced formal dissolution proceedings against the Archewell Foundation. Investigators cited failures to comply with bilateral financial disclosure requirements, possible misclassification of foreign income linked to international wellness tours, and irregular staff payment structures over multiple years. The foundation's remaining assets were frozen pending audit review. Digital control followed financial control. Trademark filings, server access records, and archive communications associated with Meghan's royal-era branding were transferred to the Crown's Digital Accountability Tribunal, chaired by Lord Julian Ashcroft. Perhaps the most emotionally charged dispute centered on a single social media account, a joint profile created to document the children's lives. Meghan filed a motion seeking sole control, arguing that she had founded the account as a maternal storytelling space. Prince Harry's legal team responded with just one sentence: "This is not a brand. These are children." The platform suspended the account indefinitely. While digital restrictions tightened, a quieter but deeply significant development was taking place inside Windsor. Lady Louise Windsor, now in her early 20s, had been appointed youth liaison to the Sussex children. Under Princess Anne's direction, she was granted structured access to their educational and residential environment. Her role was carefully defined: maintain emotional stability, ensure continuity of routine, protect the children from narrative conflict, provide grounding during transition. A royal coordinator described it simply: she is not there to raise them. She is there to anchor them. Observers noted her arrival at the Royal Learning Center carrying books, therapy materials, and a worn copy of The Little Prince, reportedly one of Lilibet's favorites. Around the same time, Princess Catherine delivered a keynote address at the Royal Digital Ethics Institute. Speaking broadly about childhood privacy in the digital age, she warned that a child's likeness can easily become currency in modern media systems. "That is not parenting," she said quietly. "That is projection, and projection is not love." The audience gave a standing ovation. Hours later, Kensington Palace released a photograph. Catherine seated beneath a tree with Charlotte, George, and Louise, reading together in an unbranded setting. The caption contained only 4 words: "Let children be children." That evening, Meghan's team distributed a recorded voice message to multiple media outlets. In it, she warned that if she were erased from her children's story, she would expose private communications and internal records. But institutional momentum was already moving faster than public messaging. Streaming platforms removed or suspended Sussex-related projects. Podcast libraries were delisted. Fashion partnerships were quietly withdrawn. Production contracts entered indefinite review. And then, something unexpected happened. Silence. Public appearances stopped. Social media activity ended. Scheduled interviews vanished from media calendars. Her website displayed only a single message, a static thank you page. For the first time in years, Meghan Markle was no longer trending. But behind that silence, 2 court systems were preparing to make decisions that would shape everything that followed. In London, the High Court's Family Division convened under sealed proceedings. In California, Santa Barbara Superior Court began parallel deliberations. Both courts were bound by a shared legal framework, the Windsor, California Reciprocal Protection Accord of 2024, a little-known but powerful agreement governing shared jurisdiction over royal minors with dual citizenship. What they would decide next would determine not just custody, but control. Behind sealed doors on 2 continents, the final phase of the conflict had begun. In London, the proceedings were led by Justice Rowena Blackstone, a judge known for strict adherence to constitutional precedent. In California, the case was overseen by Judge Everett Miles, widely respected for handling complex interstate custody disputes involving international law. Each court operated independently, but both were bound by the same transnational legal structure, the Windsor, California Reciprocal Protection Accord of 2024. Their task was not simple. They had to determine whether the 2020 Sussex Marital Compact, the document granting emergency custodial authority to the Crown in the event of marital breakdown, was legally valid across jurisdictions. They had to consider Meghan's claim that the agreement had been signed under pressure, with incomplete information, and within an unequal institutional environment. They had to evaluate Prince Harry's request to formalize royal guardianship under the Royal Minor Protections Act of 2025. And most importantly, they had to decide what arrangement best protected the emotional and psychological stability of 2 children living inside a global legal conflict. Court insiders later confirmed that 4 key witnesses provided private testimony. Lady Geneva Hartley, the Royal Child Welfare Observer, reported that Meghan had not complied with scheduled child welfare check-ins for several months. Dr. Angela Delaney, a child psychologist, described signs of emotional stress and confusion observed during recent supervised interviews with Lilibet. Caleb Wren, a former Archwell operations officer, testified that Meghan had restricted Harry's involvement in decisions related to schooling and public exposure. And Lady Louise Windsor submitted a written journal documenting the children's adjustment period, including one recurring question Lilibet reportedly asked more than once. Why do I only see mommy on camera? That question, insiders said, shifted the emotional weight of the proceedings. The focus moved away from abstract legal arguments and toward the lived reality of the children themselves. Meghan's legal team continued to argue that royal structures could not override maternal rights under U.S. law. They maintained that institutional guardianship was ceremonial rather than legal, and that inherited authority should not determine custodial outcomes. But the marital compact proved difficult to challenge. Records showed that Meghan had attended multiple drafting sessions before signing it. She had reviewed revisions. She had approved final language. And the agreement carried signatures from royal legal officers and international liaison authorities. One California official reportedly remarked that if the arrangement constituted coercion, it was unusually structured and extensively negotiated. As both courts moved toward judgment, speculation spread across media and diplomatic circles about the likely outcome. Many believed the dual sovereign guardianship structure would be imposed, preserving Prince Harry's parental status while transferring operational custody to designated royal guardians. The palace released only a single statement, while deliberations continued. The matter of custody concerning the minor heirs of Henry Charles Albert David Windsor has been resolved through sovereign and international legal cooperation. No further comment will be issued. When the rulings were finally delivered, they came within hours of each other. In California, Judge Everett Miles concluded that the cross-jurisdictional framework established in 2020 was legally binding. The court formally recognized the Crown-appointed guardianship structure as enforceable under U.S. law where dual sovereignty agreements applied. In London, Justice Blackstone issued a parallel ruling under the Royal Minor Protections Act, and in light of documented concerns regarding privacy exposure and custodial instability, direct institutional oversight will be established in partnership with Prince Harry. The decision fundamentally reshaped the family structure. Prince Harry retained biological parenthood and shared legal responsibility, but day-to-day educational and domestic guardianship was assigned to Princess Catherine. External affairs and transitional coordination would be overseen by Duchess Sophie of Edinburgh. Meghan Markle's custodial authority was suspended for a period of 5 years, pending psychological review and demonstrated compliance with institutional safeguards. Her parental access was reduced to one supervised video call per week under professional mediation. In-person visitation was limited to quarterly meetings at neutral UK-based facilities, not at royal residences. She no longer held authority to determine schooling, travel, media participation, or public exposure. The court cited commercial risk, repeated jurisdictional conflict, and failure to adhere to agreed custodial frameworks as primary reasons for the restrictions. A separate ruling from the Court of Royal Titles and Privileges followed shortly after. The Advisory Council, rarely convened in modern times, determined that Meghan Markle will be permanently barred from using Windsor-linked designations in commercial, philanthropic, or political activity without Crown authorization. This included all references to Duchess of Sussex branding, joint royal foundations, and public use of the children's royal titles. The UK Charities Commission then concluded its investigation into the Archewell Foundation. The organization was formally dissolved. Investigators cited financial reporting irregularities, foreign lobbying concerns, and structural noncompliance with royal charity governance standards. Remaining unrestricted funds were reassigned to child welfare organizations selected under Princess Anne's oversight. In the days that followed, Prince Harry was seen arriving quietly at a private terminal near Heathrow. He carried no entourage, no press presence, only a small canvas bag and a children's toy tucked under one arm. He traveled not to California, but to Wolverton Cottage. The residence had been designated as a transitional family environment for the children's new living structure. There, he met with Princess and to review educational planning for the coming year. He met with Lady Louise Windsor, who presented a short video compilation documenting the children's adjustment period at Sandringham's youth retreat. For the first time in years, Harry remained overnight on royal grounds without public conflict. A palace aide described the moment not as a return, but as acceptance. Across the Atlantic, Meghan Markle withdrew from public view. A brief sighting at a Brentwood cafe described her as distant and quiet. Her media schedule cleared. Production partnerships dissolved. Brand negotiations halted. An internal communication from her public relations agency summarized the situation with stark clarity. Reputation recovery is not possible under simultaneous litigation, institutional restriction, and custodial limitation. Strategic silence is recommended, and silence followed. Social media accounts went inactive. Her official website displayed only a static closing message. No interviews were scheduled. No public statements were issued. For the first time in years, there was no response. At Sandringham, Princess and released the monarchy's final institutional message. The matter is closed. The children are safe. The future is guided by principle, not power. We do not erase. We protect. We do not retaliate. We recover. Later that evening, Princess Catherine visited a children's hospice. She placed a handwritten note beside a small teddy bear. It read, "For every child who felt watched, may they now feel seen with love, not strategy." The House of Windsor had endured crisis before, but this time it had responded not with delay, but with decisive structure, duty over drama, protection over profit. Legacy over ego. Meghan Markle's connection to the royal institution had reached its formal endpoint, and for Prince Harry, the next chapter would not unfold before cameras. It would unfold quietly, and for the first time in a very long time, off record,